Have you heard of a case called Make the Road versus McAleen?
Make the Road New York, yes.
Yeah, okay. Make the Road in New York, who are they?
Make the Road New York is a nonprofit that represents various individuals in the sort of immigration law
Right.
field.
They're a nonprofit advocacy group for immigration issues. Did you know they received large donations from the Arabella Network and from George Soros's Open Society Foundation Network?
No,
Okay, well, they did. Now, in that case, what was the issue?
the issue in that case was a challenge to a change in administration policy concerning expedited removal, which is a policy that Congress enacted in order to expedite certain removals in the immigration system. Ordinarily, before expedited removal,
Asylum cases do not fall in this category, right?
well,
Trust me on that, because the statute says it doesn't.
if a person who could otherwise be subject to expedited removal makes and has a credible fear of torture in their country, they can be
And can they make that claim?
they
Right.
can be determined
Right.
to qualify for regular removal rather than
Right.
expedited removal.
So expedited removal is a creature of Congress, folks. And if you've been here 2 years or less, the statute, the statute, I'm sorry, the statute. The statute would allow the administration in office to have expedited removal, avoiding a lot of the hurdles that would exist otherwise for people here 2 years or less. So in the Obama, even Bush years, they did not look at it in terms of applying it to everybody. Some people coming by air got expedited removal, others didn't. The Trump administration decided to use the authority given to it by Congress to remove all eligible cases 2 years or less under the expedited removal statute. Is that a fair summary?
Well, Senator, I would say it differently.
We'll say it differently.
All right. The statute that you've put up indicates that Congress is giving the department, it says the Attorney General, but now it's the department,
Right.
the ability to determine what category of aliens.
If you've 2 years or less.
Yeah, but importantly, the authority it was not Congress saying 2 years or less. What Congress said is you, agency, have the authority to determine what category of persons who have been here between 0 and 24 months.
Which is
should
2
be.
years, yeah.
No, but forgive me,
So-
Senator, what I'm trying to explain is that the authority given to the agency was to determine what length of
They had
time.
discretion to make that
What
decision.
length of time? It was not the authority to deport everyone who's been here for 24 months. It was the authority to determine what length of time a person has to be here in order to be subjected to expedited removal.
Here's what the statute said. The Attorney General, which is actually the DHS Secretary, may apply clauses 1 and 2 of this subparagraph to any and all aliens described in subclass 2 as designated by the Attorney General, actually DHS. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. Now, I've been in this business for quite a while. What the Trump administration did was to use the discretion given to it by statute in a way different than prior administrations. This advocacy group, the Arabella-supported advocacy group, tried to strike it down. You rule for them. Here's what the D.C. Circuit Court said about your ruling. There could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expanded removal within statutory bounds to the Secretary's independent judgment. The forceful phrase, sole and unreviewable discretion, by its exceptional terms. Such designation shall be in the sole and unreviewable discretion of the Attorney General and may be modified at any time. To those of us in the law writing business, I don't know how you could tell a judge more clearly that the administration, the agency in question, has discretion to do certain things within the statute. So this is an example to me, and you may not agree, where the plain language of the statute was completely wiped out by you. You reached a conclusion because you disagreed with the Trump administration, and the D.C. Circuit Court of Appeals said, as I've quoted just a minute ago, there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within the statutory bounds to the Secretary's independent judgment. That, to me, is Exhibit A of activism. Let's go back to the child pornography cases.
Senator, would you allow me to?
Yes, please.
Thank you. The statute and the circumstances that you reference are accurate insofar as that is what the statute says. It's not all of it. It doesn't describe the designation process that I was trying to articulate. And it doesn't address the fact that Congress has another statute that is presumptively applied in agency cases to tell agencies how to exercise discretion. There's also D.C. Circuit case law that says that in addition to having that procedural statute be presumptive, even very clear designations of authority to an agency may still be subject to Congress's other directions regarding how to exercise the discretion.
That argument fell on deaf ears.
Understood. That's our appellate process.
I've got other things I want to talk about. You've given an explanation, but it didn't work. The D.C. Circuit Court said there could hardly be a more definitive expression of congressional intent. This is good as it gets. There's no way to write a statute saying discretion lies in an agency. It's sole. It's non-reviewable. So you're not convincing me that
With
this was
respect,
anything
Senator,
other than activism, and we can talk about it all day long, but I agree with the D.C. Court. This, to me, is an example, Exhibit A, of a judge ignoring limitations placed in the law by Congress to get a result they wanted.